There is a question that surfaces at every dinner table where ambition has taken a seat. It lurks in the corridors of universities, hangs unspoken at family gatherings, and occasionally erupts into open argument between two people who each believe, with full sincerity and perhaps a touch of arrogance, that their path demanded more. The question is simple. The answer is anything but. Who works harder, the doctor or the lawyer? I have spent decades in courtrooms arguing cases that shaped industries, toppled governments, and changed what it means to live in a free society. I have sat across tables from brilliant minds, scientists, engineers, surgeons, financiers, and I have come to understand something that most people arguing this question refuse to acknowledge. The comparison itself is a kind of distraction. It is the wrong question dressed up as the important one. But let us ask it anyway, because buried inside the wrong question are truths worth excavating. The education problem nobody talks about. When you enter a law school on your first day, something extraordinary and quietly troubling happens. You are not taught law. You are taught to think about law. You are given theories, competing frameworks of justice, stacked one against the other, each with passionate defenders and compelling logic. You learn that the law is not a fixed object, but a living argument. You learn that two equally intelligent, equally trained attorneys can look at the same set of facts and arrive at opposite conclusions, and both be right. That sounds profound, and it is, but it is also a serious problem. Imagine if medical school operated this way. Imagine sitting in a lecture hall on your first day of anatomy and the professor walks in and says, "Today we are going to discuss science. Not how to read a scan, not what the femoral artery does, not the mechanics of an aortic valve. Just science. As a concept, as a philosophy, as a contested space of human inquiry." Then the next day, a different professor walks in and says, "Well, science is one perspective, but some people believe in intelligent design." And the day after that, someone else arrives to present mysticism as a third framework worthy of serious consideration. You would be appalled. You would demand your tuition back. You would question every decision that led you to that classroom. And yet, this is, in many essential ways, what law school is. Not mysticism, no, but competing theories, dueling frameworks, endless argumentation about what justice is, what it should be, and why someone smarter than you once believed the opposite of what you now believe. Law school does not teach you to be a lawyer. It teaches you to think like one. And when you finally leave, when you pass the bar and hang your shingle and walk into your first real courtroom, you discover that thinking like a lawyer and being a lawyer are two very different things. The gap between them is where most young attorneys stumble. Some never find their footing. This is not a criticism, it is an observation. Law school is training for the mind. Medical school is training for the hands and the mind simultaneously. These are not equivalent experiences. They are not supposed to be. Medical school demands 4 years of formal education, followed by 3 to 7 years of residency, of postgraduate training so intense, so consuming, so physically and emotionally brutal that the people who survive it emerge fundamentally changed. They are not just smarter than when they entered. They are different. They have been tested by sleep deprivation, by death, by failure, by the particular weight of knowing that the decision you make in the next 30 seconds will determine whether someone's child goes home or does not. Call shifts, clinical rotations, boards upon boards upon boards, first year, second year, at graduation, at specialization. The testing never stops. The examination of competence never ends. A physician cannot decide one morning that they have been tested enough. Medicine is a discipline of perpetual accountability. Law school is 3 years. This is a fact. It does not make law easy. But it is 3 years, and the mathematics of time matter. What the examination reveals here is something that law students almost never discuss publicly but know privately: the cruelty of law school finals. In most law school courses, your entire grade, or the overwhelming majority of it, rests on a single examination at the end of the semester. Sometimes there is a midterm worth 20%. Sometimes participation earns you 10. But in the vast majority of cases, you walk into that examination room carrying the full weight of the semester in your hands, and what you produce in those 3 or 4 hours will define your academic trajectory, your job prospects, and in many cases, the entire shape of your early career. This is brutal in its own particular way, not because the exam is impossible, it is not, but because it is unforgiving of variance. There is no averaging out a bad week. There is no redemption through consistent effort over time. You perform on that day, in that room, under that pressure, or you do not. The law rewards a specific kind of composure. The ability to organize complex information under acute stress and deliver it with precision is not just an examination skill in law school. It is the skill of lawyering itself. And yet, and here is where the comparison becomes genuinely interesting. Medical students face something different in kind. Not one high-stakes exam per semester, but an unrelenting cascade of tests, each one building on the last, each one tracking your competence in real time. Board exams at multiple points in training, certification examinations, peer review, patient outcomes that speak for themselves. A physician cannot simply know the theory of medicine on one critical day. A physician must demonstrate mastery continuously in the presence of sick and vulnerable human beings with consequences that are immediate and irreversible. Both systems demand excellence, but they demand it differently, and the difference tells you something important about what each profession is actually for. The institutions that shaped them. UCLA, the greatest public university in the world. And I say that not merely as an opinion, but as a statement that the data has repeatedly supported. A place where the best minds in California, and increasingly the world, come to be tested, refined, and sent back into society carrying the institution's standard. To complete both an undergraduate degree and a law school education at such a place is not incidental. It is formative. The culture of rigor, of intellectual ambition, of competition among the genuinely gifted. These things leave marks. NYIT, New York Institute of Technology, occupies a different kind of space in the educational landscape. Not world-renowned in the way of a flagship public research university. Not a household name in the way of a coast-to-coast institution. But a place where a young man followed in his father's footsteps, completed a 7-year combined bachelor's and doctorate program, and emerged on the other side as a physician. The meaning of that choice, to attend the school where your father trained, to pursue the same discipline through which he built his life, carries a weight that no ranking system can measure. Both of these institutions produced people who are, by any reasonable measure, exceptional. One argues cases, one saves lives. The school's prestige matters less than the standard of the mind that passes through it. The professors who refuse to let you be mediocre. What does it mean to have a devoted professor? Not merely one who shows up, not merely one who covers the material, but one who is physically upset when a student fails to understand. One who does not hide their disappointment behind professional distance, but lets it show, lets it burn, lets it communicate to the student in the room that this, whatever this moment of confusion or inattention or intellectual laziness is not acceptable. That is a certain kind of love. It is not the comfortable kind. It is the kind that produces surgeons and trial lawyers and anyone else who eventually has to perform in situations where failure is not permitted. The law professors who challenge most powerfully are the ones willing to get in your face, willing to debate, willing to let the classroom become a sparring room rather than a lecture hall. There is a memory, small but telling, of a criminal law professor who, when met with a dismissive, "Isn't that just a semantic difference?" did not let it pass, did not smile and move on. Instead, "Well, isn't everything a semantic difference? Isn't that precisely why we're here?" That is a professor doing their job at the highest level. That is someone who understands that the law lives in language, that precision in language is not a pedantic concern but a moral one, and that a young attorney who learns to wave away semantic distinctions will one day wave away the clause that costs their client everything. Medical professors, by different means, create the same urgency. The cadaver lab, where medical students work directly with human remains, where the abstract becomes tactile, where the body becomes something you are responsible for understanding with your hands, is a form of education that has no equivalent in law school. Law students read about cadavers. They read about autopsies and toxicology reports and the biological realities that underlie the cases they argue. But they do not touch. They do not hold. They do not develop the muscle memory of someone who has performed a procedure 1,000 times before the stakes were real. This distinction matters, not because it makes medicine harder or law easier, but because it makes them different in ways that resist easy comparison. The company you keep. There is something that happens when you spend 3 years surrounded by the highest concentration of genuinely intelligent people you have ever encountered. It changes your baseline. What once seemed like impressive reasoning now seems ordinary. What once seemed like a sophisticated argument now seems like a starting point. The standard rises invisibly and relentlessly, because everyone around you is operating at a level that forces you to operate there too. Law students bring their own lamps to the library. They carry chair cushions. They bring water bottles calibrated to monitor fluid intake. This is not obsession. This is what people who are genuinely serious about a difficult task look like when they are in the middle of it. Medical students are no different. They are, in their own domain, equally devoted, equally competitive, equally shaped by the peer culture that surrounds them. The difference is that medical students are also shaped by patients, by the actual human beings whose bodies demand competence before they are ready to give it. There is no mock patient. There is no simulation that fully substitutes for the real thing. At some point, every physician must make a real decision about a real person, and every outcome thereafter belongs to them. Law students have mock trials, and mock trials, make no mistake, are more than games. They are the closest simulation that legal education offers to the real thing. 2 parties, opposing positions, evidence, witnesses, a judge, and the obligation to persuade. Mock trial is where future trial attorneys discover whether they have the temperament for the courtroom, whether they can think on their feet, whether they can absorb a devastating blow, a ruling that goes against them, a witness who says something unexpected, an argument they did not anticipate, and continue. The ability to continue is not a small thing in trial practice. It is, very often, the thing. Winning national championships in mock trial competition is not incidental. It is predictive. The skills it develops, rapid analysis, composed delivery, adaptive strategy, the management of an adversarial environment, are the skills that will determine whether a young attorney becomes exceptional or merely competent. What money reveals about commitment. Let us talk about money, because money is never just about money. When someone chooses medical school, they are making a financial commitment of such magnitude that it amounts to a declaration of purpose. Combined programs, 7 years of undergraduate and doctoral training, represent not just tuition, but years of foregone income, years of deferred adulthood, years of living in the strange suspended state of perpetual studenthood. And then, when the degree finally arrives, it does not immediately translate into financial stability. Residency is not well compensated. By some calculations, residents earn approximately $10 per hour when their actual hours are factored in against their salary. And this goes on for years. Years during which loans are accumulating interest. Years during which peers who chose different paths have been earning, saving, building. The willingness to accept this, to accept years of financial exposure in service of a professional calling, says something about the seriousness of the commitment. It says something about what medicine means to the people who choose it. Law school is 3 years, which makes it less expensive simply by virtue of being shorter. Some students live at home, which reduces costs further. But the debt load upon graduation is still significant, and the pressure it creates, the pressure to take jobs that pay well immediately, sometimes at the expense of the work that actually matters to the lawyer, is real and worth naming. Both professions extract a financial toll in exchange for the privilege of entry. The toll is different in structure, similar in weight, and in both cases it shapes the kind of person who survives the extraction. Romance in the foxhole. There is a reason military units develop intense bonds. There is a reason people who go through difficult things together tend to stay together, or at least carry each other for the rest of their lives. Shared suffering is a powerful social adhesive. Law school is no different. When you spend every waking hour with the same group of people, studying in the same rooms, panicking about the same finals, debating the same cases, collapsing in the same cafeteria, something happens to the social fabric. Relationships form. Romances ignite. Partnerships begin over shared outlines and late-night case briefing sessions. The intensity of the environment creates intimacy by proximity, and the intimacy sometimes becomes something more. Medical school and residency produce the same dynamic, perhaps more intensely. The heightened stakes, the physical exhaustion, the shared exposure to suffering and death. These forces either drive people apart or draw them together with extraordinary force. The romances of medical training are legendary, not because medicine attracts more romantic people, but because the conditions of medical training are precisely the conditions under which human beings seek connection. To say you never thought about romance during medical school, to insist that the pressure was so total, the anxiety so consuming, that relationships simply fell away, is either an extraordinary act of discipline or a gentle revision of history. Perhaps both. Perhaps the truth is that the anxiety was real, the focus was real, and the not thinking about it was also a choice that had to be consciously made. What we can say with confidence is this: the people who emerge from these programs, from law school, from medical school, from the long gauntlet of both, have been tested in ways that reveal character. And character, in the end, is what both professions are actually selecting for. The advice that actually matters. If you are standing at the beginning of a legal education, here is the most important thing I can tell you. Know why you are there. This may sound obvious. It is not. A significant number of people enter law school not because they want to be lawyers, but because they do not know what else to do. They were good students. They have a facility with language and argument. Law school seems like a reasonable response to these attributes, and so they arrive, at great expense, with significant investment of time, without a clear answer to the question of what they actually want to become. This is a mistake, not a fatal one but a costly one in more ways than financial. The law is too serious a discipline to enter without intention. The stakes in legal practice, the liberty, property, and dignity of actual human beings, are too high to be treated as a default setting by someone who couldn't think of anything better to do. If you want to be a lawyer, go to law school. If you want to find yourself, there are cheaper and more honest ways to do it. The other critical piece of advice, specific to the mechanics of legal education, is this: memorizing the law is not the same as mastering the examination. Law school finals are not tests of memory. They are tests of application. They are issue-spotting exercises in which the student must read a fact pattern, identify the legal issues embedded within it, apply the relevant law to each issue, and reach a defensible conclusion, all within a time constraint that permits no hesitation, no backtracking, and no confusion about where you are in the analysis. There is an art to this. It must be learned deliberately, practiced repeatedly, and refined through feedback. The students who succeed at law school finals are not necessarily the students who know the most law. They are the students who have internalized the structure of legal analysis so thoroughly that they can deploy it under pressure without thinking about the structure itself. Like a surgeon who no longer thinks about how to hold the scalpel because the motion has become automatic, leaving the mind free to focus on the tissue. For medical students, the parallel advice is about something different: the management of sequential pressure. The boards never stop. The examinations never cease. The certifications continue long after graduation. If you attempt to hold all of it in your mind at once, if you try to feel, simultaneously, the weight of every test that lies between you and the end of your training, you will not be able to function. The only answer is the one that athletes and soldiers and anyone else who must perform under sustained pressure eventually discovers: one challenge at a time, one test at a time, one board at a time. The future cannot be addressed until the present has been handled, and anxiety about the future will impair your performance in the present, guaranteeing the worst of both. The question the debate cannot answer: which is harder, med school or law school? I have watched this debate unfold, watched two sharp minds circle each other with genuine respect and competitive instinct in equal measure, and I want to tell you something that neither of them quite said directly. The question assumes a common unit of hardness. It assumes that difficulty can be measured on a single axis, that the challenges of memorizing pathophysiology and the challenges of mastering legal reasoning can be lined up against each other, and one can be pronounced greater. This assumption is false. Medical school requires you to absorb a staggering volume of factual information, biological, chemical, pharmacological, in a compressed period of time, and then to apply that information in clinical settings where the margin for error is measured in human lives. The breadth of the subject matter is extraordinary. The stakes of incompetence are immediate and irreversible. Law school requires something different: the development of a particular kind of reasoning that does not come naturally to most people, a tolerance for ambiguity and competing truths, and the ability to construct and destroy arguments under conditions that favor neither side by default. The law does not have a correct answer in the way that medicine has a correct diagnosis. The law has better and worse arguments, and the ability to construct the better argument and dismantle the worse one is the entire game. These are different skills. They are both demanding. They are both worthy. The person who can do either well has something rare and valuable. But here is what I will say, having spent a career in the practice of law at its highest levels: the gap between law school and legal practice is larger than it should be. The gap between what legal education teaches and what the courtroom requires is a genuine problem, not just for young attorneys, but for the clients who depend on them. Medical education, for all its brutality, seems to close this gap more effectively. By the time a physician is operating independently, they have already faced real consequences. They have already made decisions that mattered. They have already been accountable for outcomes that could not be undone. Young lawyers often arrive in practice without this seasoning. They arrive with theory and with the language of law, but without the instinct that only comes from having stood in front of a real judge and made an argument that real consequences depended on. This is not a criticism of the individuals. It is a structural problem with how legal education has been designed. Fixing it, building a legal education that closes the preparation gap, that gives students not just the theory of law, but the practice of it before they are standing in a courtroom holding someone else's future, would be one of the most valuable investments the legal profession could make. Where the two professions converge, there is a moment that every physician and every trial lawyer eventually faces, and it is the same moment despite the different settings in which it occurs. The moment when the preparation is over. The moment when the studying and the theorizing and the rehearsing have run out, and what remains is the actual situation: a patient on the table, a jury in the box, a life in your hands, a verdict in your words. In that moment, what matters is not where you went to school. What matters is not how long your program was, or how expensive your loans are, or whether you had time off during training. What matters is whether you are ready. Whether the years of preparation, all of it, the grueling and the exhilarating and the humiliating and the transcendent, have produced someone who can perform when it counts. That readiness is what both professions are ultimately trying to create. The methods differ, the timelines differ, the texture of the challenge differs, but the target is the same: a human being capable of showing up fully, under pressure, in service of someone who has nowhere else to turn. The doctor who walks into an emergency room at 3 in the morning and the lawyer who stands before a jury to deliver a closing argument are, at that moment, the same kind of person. They are someone who has been tested and has not broken. Someone who carries knowledge not as an ornament but as a weapon deployed with precision in the service of another human being. That is what education is for. Not the grades, not the rankings, not the prestige of the institution or the elegance of the argument about which path was harder. The point is to become someone capable of that moment. And if the education, however long, however expensive, however relentless, produces that person, then it has done its job. I have been asked to render a verdict. It is, after all, what lawyers do. Here is mine. Medical school and residency together constitute a longer, more volume-intensive, more clinically immediate preparation for practice. The sheer quantity of knowledge required, the duration of formal training, the continuity of high-stakes testing, and the direct exposure to patient care before full independence. These factors make the pathway to practicing medicine longer and, in certain measurable respects, more demanding. Law school is shorter and more theoretically structured. Its preparation for practice is incomplete in ways that medical training is not. The gap between graduation and competency must be bridged through experience rather than through formal training, which places the burden on the young attorney rather than on the institution. But here is the complication. The practice of law at its highest levels, litigation before sophisticated courts, the construction of legal strategies that must survive the scrutiny of brilliant opposing counsel, requires a form of intellectual agility that has no direct parallel in medicine. Medicine has correct answers, or at least better and worse answers that can be evaluated against objective outcomes. The law often does not. The law lives in the space of competing arguments, and to navigate that space masterfully is to possess something rare. So, medicine is a harder education. Law is a harder practice to master. They are both harder than most people believe, and both less understandable to outsiders than their practitioners would like to admit. The doctor and the lawyer, in the end, need each other more than they need to win this argument. Medicine generates malpractice. Law generates medical expert witnesses. The courtroom and the operating table are not enemies. They are, in some profound sense, partners in the project of human accountability. And that, the project of human accountability, is what both professions exist to serve. Not prestige, not the satisfaction of winning a debate, not even the intellectual pleasure of the work, though that pleasure is real and sustaining. The point, always, is the person on the other side of the table, the patient who needs the right diagnosis, the client who needs the right argument, the human being who has handed their vulnerability to a professional and asked in the most fundamental way possible, "Can you help me?" That is the question that makes both professions serious. That is the weight that justifies every grueling year of training, every missed evening, every examination taken under conditions designed to reveal the limits of human capacity. You do not go into medicine or law to win an argument about which is harder. You go to become someone worthy of the trust that question implies.